This is Bloomberg Law with June Grasso from Bloomberg Radio.
Mexico is suing U.S. gun makers for $10 billion, alleging they've fueled cartel gun violence. But it appears that Mexico's lawsuit will end at the Supreme Court, where both liberal and conservative justices appeared skeptical that the claims could clear hurdles in U.S. law that largely shield gun makers from lawsuits when their products are used in crime. Liberal Justice Elena Kagan questioned whether Mexico's allegations were specific enough to hold the gun makers like Smith & Wesson liable for specific dealers that sell firearms in bulk to straw purchasers who traffic the guns across the border.
What you don't have is particular dealers, right? I mean, there are lots of dealers, and you're just saying they know that some of them do. But which some of them? I mean, who are they aiding and abetting in this complaint?
And conservative Justice Brett Kavanaugh said he had real concerns that allowing the case to go forward would have repercussions for U.S. companies when their products are misused.
You know, we manufacture knives, but there are a lot of stabbings in certain neighborhoods. We should make sure our products aren't sold there, or a sporting goods company and baseball bats are used to, storm CVS's or what have you. So we shouldn't sell in this city, or prescription drugs are misused in a certain area. So we need to be alert and make sure. Is that where your theory of aiding and abetting leads, that you have to be kind of tracing everything down the chain?
My guest is Andrew Willinger, Executive Director of the Duke Center for Firearms Law. Andrew, tell us about Mexico's claims in this lawsuit.
So Mexico is alleging in this case that a group of major U.S. gun manufacturers aided and abetted the illegal trafficking of guns into Mexico through straw purchasers that were conducted by people within the United States who then trafficked the guns across the border, that those guns were then used by cartels in Mexico to commit various acts of violence, and Mexico is seeking to recover for the cost of that violence that occurred in the country. And the issue before the court is whether these claims are barred by a federal statute that immunizes gun makers from certain legal claims based on the third-party misuse of their products, or whether Mexico's claims fit within one of the listed exceptions in that federal law.
That federal law is called the Protection of Lawful Commerce in Arms Act from 2005. So the exception is that it allows suits against gun makers that knowingly violate a state or federal gun law?
Yes, that's right. So this is one of a series of exceptions to the immunity shield in PLACA. It's often called the predicate exception, and it allows, as you said, actions where a manufacturer knowingly violates a state or federal statute that's applicable to the sale or marketing of a gun, and then that violation has to be the proximate cause of the harm for which the plaintiff is seeking to recover.
This suit is just at the very initial stages. There hasn't been any discovery or anything yet, has there?
No, there has not, and this is something that Mexico's counsel mentioned repeatedly during the oral argument. This is a case that has come all the way up to the Supreme Court on what's called a motion to dismiss, which means that the only thing that Mexico has done so far is file its complaint, which contains, allegations about the conduct that Mexico says these gun makers have engaged in and how that conduct allegedly has caused these damages, but there has been no discovery, and so Mexico hasn't been given the chance yet to come forward with evidence to support those allegations. The question is whether they can do so, whether the case can progress to the next stage.
So regarding that legal principle called proximate cause, Noel Francisco, the former Solicitor General who argued the case for the gun manufacturers, said that if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose. And Budweiser is liable for every accident caused by underage drinkers since it knows that teenagers will buy beer, drive drunk, and crash. That was also a concern of Justice Brett Kavanaugh, who started talking about baseball bat manufacturers being held liable if their bat causes injury.
Yeah, that's right. There are a lot of sort of extended hypothetical discussions about baseball bats, about beer makers, and sort of what level of knowledge or specific marketing to underage individuals of beer, for example, might be sufficient to give rise to liability. And, I think this is a sort of broader concern about what the impact would be in various industries of extending liability in this way. It really underlies all aspects of the case at this stage, both the proximate cause question and the question of whether aiding and abetting liability. So the theory that here the gun makers have aided and abetted these retailers who are actually selling to straw purchasers, knowing that they're going to bring the guns into Mexico, whether allowing these claims to proceed could have damaging consequences beyond the gun industry.
And what was the answer to that from the attorney from Mexico?
I heard Mexico's attorney to be making a couple of points in response. I did hear some suggestions at various points that, things like drugs, pharmaceuticals, guns, sort of products that might be inherently dangerous in some way, that maybe it makes sense to have a different approach, to have some expanded form of liability when that's the type of product that you're dealing with. I also heard a lot of emphasis on the complaint and the specific allegations in the complaint about knowledge on the part of the gun manufacturers that there are specific, what Mexico has called red flag dealers that are engaging in these straw sales. So I think Mexico also emphasizing that in this specific instance, maybe there is sort of a unique level of knowledge and complicity in the country's view that distinguishes this case from the other types of hypotheticals that we heard discussed at oral argument.
Liberal Justice Elena Kagan was one of the ones talking about what you don't have is particular dealers, right? Who are they aiding and abetting in this complaint? I mean, it seemed to be liberals and conservatives across the board were having a problem with Mexico's lawsuit.
I think that's right. That was my impression from the arguments as well. And actually, I thought was notable as well that Justice Tanji Brown Jackson had this line of questioning both for Noel Francisco and also for Mexico's counsel that, she seemed to be very concerned about this threshold issue of whether PLACA even contemplates sort of broader common law aiding and abetting as a potential predicate exception claim that could be brought notwithstanding the immunity shield. So she seemed to be voicing some concern that maybe, Congress, when it enacted PLACA, was actually thinking about something far narrower in terms of the lawsuits that it would allow. And she was worried, it seemed, about courts, about judges putting in their own more expansive view of what the exception could permit. So I thought that was interesting. And, it's always difficult to speculate about how a justice will vote based solely on their questions at oral argument. But Justice Jackson seemed very concerned about that point, and it would suggest to me that maybe she's more, on the fence or maybe even on the side of the gun makers in this case.
So then what issue do you think the decision will turn on?
If I had to predict, I think, based on how the argument went today, it's most likely that the court will decide this on the aiding and abetting point, that the court won't really want to get into the proximate cause case law, which, at various times in the arguments, we heard it called kind of a mess and very muddled, and, that it's not clear exactly, what the court requires in terms of proximate cause and its past case law. So there seemed to be more of an appetite among several of the justices to decide on the basis of aiding and abetting, which would mean, as I suspect, the court sides with the gun makers and then throws this case out. It would say that Mexico's allegations did not plausibly establish an aiding and abetting violation of the straw sales by these retailers further down the line.
So then could Mexico come back with new information, specific dealers or straw purchasers or whatever, that would allow them to bring the case again?
I think that's possible. I could imagine there being a more limited case where there, and again, reading a little bit between the lines of the argument today, some justices seem to maybe be pushing in this direction, that if this were a complaint that was based on specific transactions, where Mexico is saying, these specific gun makers sold these guns to these distributors and then dealers, and they knew that they were going to go into the hands of straw purchasers and go into Mexico on a transaction by transaction basis, listing that out, that maybe that would be a different outcome. That would obviously be a much different type of case. The damages would presumably be much lower because we would be talking about fewer guns. But I think that's theoretically possible.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Andrew Willinger of Duke University. This argument comes at a fraught time for U.S.-Mexico relations. There seemed to be an oblique reference to that in a question from Justice Samuel Alito.
There are Americans who think that Mexican government officials are contributing to a lot of illegal conduct here.
More on the oral arguments coming up next. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court seems likely to block a $10 billion lawsuit Mexico filed against top firearm manufacturers in the U.S., alleging the companies have fueled cartel gun violence. Mexico has strict gun laws and has just one store where people can legally buy firearms. But thousands of guns are smuggled into the country by powerful drug cartels every year. The Mexican government says 70% of those weapons come from the United States, and the lawsuit claims that companies' new weapons were being sold to traffickers who smuggled them into Mexico and decided to cash in on that market. The companies reject Mexico's claims, arguing it comes nowhere close to showing they're responsible for a relatively few people using their products to commit violence. I've been talking to Andrew Willinger, Executive Director of the Duke Center for Firearms Law. Andrew, this comes at a fraught time for relations between the U.S. and Mexico, with President Donald Trump imposing 25% tariffs on Mexican imports, and the Mexican president promising to impose retaliatory tariffs. Trump has said the tariffs are aimed at forcing Mexico to step up its fight against illicit drugs and illegal migrants crossing the southern border. I didn't think that would enter into the arguments today, but then Justice Samuel Alito asked the lawyer representing Mexico this question.
There are Americans who think that Mexican government officials are contributing to a lot of illegal conduct here. So suppose that one of the 50 states sued the government of Mexico for aiding and abetting illegal conduct within the state's borders that causes the state to incur law enforcement costs, public welfare costs, other costs. Would your client be willing to litigate that case in the courts of the United States?
I thought that was a very aggressive question that clearly revealed his position.
Yeah, I was very surprised to hear this question be asked at oral argument. I will say, Justice Alito did preface it by sort of, put it, with some kind of disclaimer of, this doesn't actually relate to any of the legal issues in the case, which of course it doesn't. And, it's certainly true that this is going on in the background, that, the case itself has become kind of a bargaining chip in some sense in these negotiations or discussions between the U.S. and Mexico. But it wasn't clear to me exactly what this question was meant to do, other than just to kind of put this idea on the record, because clearly, Mexico's attorney in this case was not going to, go down the path of saying that the Mexican government would waive its sovereign immunity in some kind of future hypothetical litigation. So this surprised me as well. I didn't expect it to come up so viscerally at oral arguments.
Yeah, I felt for the attorney at that point, because how could she possibly answer that question? Thinking back on the arguments, I'm trying to think if there was one justice who clearly came out in favor of Mexico's position. Perhaps Justice Sonia Sotomayor in part?
I think that's right. I think Justice Sotomayor was sort of, maybe pulling out the best or most direct theory of the case for Mexico in terms of what was being alleged. And I think she was also, if I heard her questioning correctly, maybe putting the relevant point in the causal chain sort of further down the line, which would help make proximate cause potentially an easier sell, right? So she was saying, well, you really need to look at the point at which the guns are sold and not necessarily the upstream actions of the gun manufacturers. And, that's sort of the way vicarious liability and aiding and abetting works. And so that's where you're starting. You don't have this, 6 or 8 step causal chain that, the gun makers have been referring to in their briefing and argument.
There were questions about whether the manufacturers are designing and marketing their guns in order to drive up demand among the cartels. For example, they have this special edition Colt handgun called the Super El Jefe pistol. And engraved there is the Mexican revolutionary Emiliano Zapata's pronouncement, "It's better to die standing than to live on your knees." I mean, did that play any part in this? The fact that they may be actually designing some weapons to appeal to Mexicans?
This did come up a little bit, towards the end of the oral argument, and it seemed to me like, the response to that among the justices was a little bit skeptical. I think due to the fact that, as one of the justices noted, it's not clear of those specific types of firearms. There didn't seem to be evidence of what percentage were actually the ones that were being diverted into Mexico. So there seemed to be maybe a missing link there. And then, of course, the fact that maybe these are things that some consumers in the United States want too. I think the justices seemed skeptical that this rose to the level of the kind of deliberate targeting that was discussed in some of the other contexts where you might have, a beer manufacturer that's, designing something specifically for people who are underage, right? So they seemed skeptical, in my view, that this was at the same level.
So do you think they'll just write an opinion throwing out the case, or that the opinion might have implications for other cases?
This case, of course, is a little bit unique, deals with a foreign country. I think one of the real questions will be what impact, if any, the decision has on domestic tort lawsuits against the gun industry, and specifically lawsuits that are brought pursuant to a recently enacted set of laws in a handful of states that are designed specifically within the predicate exception and provide, a statutory claim. These are sometimes called firearm industry nuisance statutes that have been passed in states like New York and California, for example. And, I think it's going to depend on what basis the court decides this case, what the impact on that domestic sphere will be, because one of the reasons that states are passing these laws is to have less doubt out there about whether a predicate violation is actually something being alleged. So instead of having to rely on the type of aiding and abetting theory that Mexico did here, if you are operating under one of these state laws, you have an actual statute that you can point to and say, I'm alleging that this gun manufacturer violated this specific state law. But on the other hand, there's still proximate cause requirements. So to the extent the court does say something about proximate cause, that could have an impact on these domestic lawsuits. And, anything that is in that opinion that talks more broadly about PLACA, about the intent of PLACA, what types of lawsuits PLACA was meant to sort of cut off, any of those broader atmospheric statements could be pretty impactful even in these domestic cases.
Knowing the Supreme Court's recent Second Amendment jurisprudence, do you think that this case really came to the court with sort of an uphill battle?
I think that's right. I have said that, I think that the Second Amendment cases are sort of a useful guide going in to think about how the justices might view this case. That said, that issue really didn't come up at oral argument, even though I think Noel Francisco said something about, the Second Amendment and the possibility that this was going to, these types of cases might have a significant negative impact on the gun industry, which could impact Second Amendment rights. There didn't seem to be a whole lot of engagement on those points from the justices. So while I think maybe that was a useful heuristic going in, I actually think we're likely to see a decision that doesn't break down necessarily along those lines, along that same partisan lines that we've seen in some of the major gun cases, like the Bruin case, for example, that we could see something more unanimous.
Thanks so much for coming on the show, Andrew. That's Andrew Willinger, Executive Director of the Duke Center for Firearms Law. Coming up next on the Bloomberg Law Show, Delaware's Chancery Court often gets attention because of billionaire litigants like Elon Musk and Fortune 500 companies. But a case involving a construction worker whose horse was dumped in a Delaware landfill after a hit-and-run accident highlights the Chancery Court's responsibility to deliver equity. I'm June Grasso, and you're listening.
Since I was born, I dreamed of being a Budweiser Clydesdale. Only problem is, I was born a donkey. So all my life, I practiced the Clydesdale walk.
Who hasn't felt a tug at their heartstrings as the Budweiser Clydesdales have bonded with donkeys, puppies, and yes, bulls, fought against the odds, played football in the snow, and even fallen in love with a dancing circus horse in nearly 50 uplifting Super Bowl ads. It's no wonder, then, that Brenton Marchese wanted a Clydesdale ever since seeing Budweiser's famous team when he was a boy. And his dream came true in 2015 when a friend showed him a photo of a foal named Michigan Breeze and said he could buy her for $1,100. Marchese says, "It melted my heart." Breeze became the cornerstone of his life until a hit-and-run accident last December took her from him. What followed brought Marchese to the Delaware Chancery Court and Chief Judge Kathleen McCormick, the same judge in court that Elon Musk and his online followers have been attacking for nearly a year. Joining me is Jennifer Kay, Bloomberg Law Senior Correspondent. Jennifer, tell us about the history and relationship between Marchese and Breeze.
So Brendan Marchese is a construction worker, lives in a small Delaware town outside of Wilmington and its famous courthouses. Is a pretty rural area for the most part. And he has had this Clydesdale for about a decade. He bought her when she was just a few months old. She came with the name Michigan's Breeze. And, you know, for him, it was kind of love at first sight, that first sight being a picture on a friend's cell phone. A friend of a friend was selling the horse, and he had always wanted a Clydesdale ever since seeing the Budweiser team when he was a kid. Brenton Marchese has not had, I think, the easiest life. He's definitely had some losses and some difficult relationships, but the one steady presence in his life was always this horse, Breeze, and she turned out to be that way for a lot of his friends as well. Some of them are military veterans coming home with trauma that they need to process, and instead of turning maybe to different substances, Marchese knew that he could always turn to this horse who always needed him to show up every day. And so she became kind of an emotional support animal for his social network, that she was always there, always happy to see them, always needing them to show up, and was just that kind of one steady presence. So he and Breeze, they had a routine of just going out for a short ride after work every day. And in December, it was a day like any other. They were riding back to the barn where she lived in a kind of a double stall because she's such a large horse. And unfortunately, that's when a driver came up behind them going really fast and clipped her in the hind legs just as she was moving, off the road into the shoulder of the road. And the driver briefly stopped, but then just kept right on going. And unfortunately, no one got a look at the car or the license plate. It didn't show up on any doorbell cameras in the area. And Mr. Marchese was injured. Amazingly, he walked away without any broken bones, but he was, injured at the scene, and the paramedics wanted him to go to the hospital. It was near the barn where the horse lived, so the barn's owner came out and was waiting for a veterinarian to come and take a look at the horse. And Mr. Marchese knew it was pretty bad. If a horse breaks its leg, that's usually a fatal injury. He knew it was bad, but he also knew that everybody who was at the scene knew how much he loved this horse and that he wouldn't want her just taken away and forgotten, that he would want to honor her, that he'd always said that he would plan to cremate any of his pets or animals. And so when he left in an ambulance, he kind of left her in the care of the small number of people at the scene. And unfortunately, somewhere between the accident and the hospital, he lost track of his phone. He wasn't able to get, clear word on what had happened to the horse or what was happening at the scene. So it was pretty much 24 hours later before he really got the messages that, unfortunately, the horse had to be put down there at the scene. And then someone at the scene gave the okay for the horse to be transported to a landfill. And that was the one thing that he really didn't want to do with his animal.
An attorney volunteered to help him with this?
So, like I said, it's a small rural part of Delaware, which is a pretty small state overall. It's one of those places where everyone kind of knows everyone. And so as his story was spreading in kind of the small equestrian community there outside Dover, this attorney happened to see on social media a post about his story, and she realized that she was taking riding lessons at the same barn. And so she called him up and said, hey, what can I do to help you? And I'll help you for free. I'll help you pro bono, just because he needed someone to help him walk through this Chancery court process of trying to get an order to go into the landfill to retrieve Breeze's remains.
We've been hearing about Chancery Court and the particular judge involved for quite some time because of the Elon Musk pay situation.
Chancery Court has become famous, I think, as the place that Elon Musk loves to hate, right? Because this is the court that made him buy Twitter in the first place, is the court where the same judge has said, no, your pay package at Tesla for $56 billion, that wasn't passed correctly. There were too many conflicts of interest on the board. You can't have that. The board is going to have to go back to the drawing board. He's been using those rulings as a means of attacking the court, of questioning basically the bedrock of corporate law for corporate America, for the Fortune 500. All of his criticisms has led now to new corporate law amendments being proposed in the Delaware legislature. There's a lot of criticism directed at the court that this is not how judges are supposed to act. And some of that criticism is coming from people who just really aren't regular to the corporate law world. So this court is really the home for any legal question involving the Fortune 500 because all the judges are business law experts, including this judge, Chancellor Kathleen McCormick, who has overseen the Elon Musk cases. But it's also this very traditional court where anyone who is looking for some kind of remedy that doesn't involve money, like if you have a property dispute and money isn't really going to solve the problem for you, you go to Chancery Court. If you have a will that you need to contest or an estate that's sort of in question, you go to Chancery Court. And so all of these judges also from time to time have to take on these so-called smaller cases that don't really rise to the headlines that you see with Elon Musk. It's a very old-fashioned kind of court in that sense. Most states don't have a court like this. They just kind of go through civil court regardless of what the question is. But in Delaware, there are really two civil courts, and Chancery Court is the one where you go when money isn't really going to solve the problem for you. And in this case, what Mr. Marchese wanted wasn't money for his horse. He just really wanted the horse back.
So on Christmas Eve afternoon, his lawyer gets a call from the chief judge?
So this crash happened basically late in the week before Christmas. And it was, I believe, December 23rd when the petition was filed. And the attorney, Angelica Mimani, she didn't think anybody at the court was actually going to see it until after Christmas because it was so close to the holiday and things tend to shut down for holidays. But she got word in the afternoon on Christmas Eve as she was planning to take off to see her family that Chancellor McCormick had the petition and wanted to hold a Zoom meeting that night to try to see what she could do to resolve the question because there was this urgency behind it.
So Marchese didn't consent to having his horse buried in the landfill, but they wouldn't let him on the site to retrieve her. So what were the questions that Chancellor McCormick was faced with?
It's an unusual question, for sure, to come up to the Chancery Court. And all Brenton Marchese wanted was to reclaim the remains of his horse so that he could have her cremated and he could, celebrate her life with some dignity. He didn't want to just leave her remains dumped in the landfill because he had seen other animal owners, other horse owners who really mistreated their horses. Their animals, just ended up dumped, uncared for, unloved. And Breeze wasn't unloved. Breeze was a dearly beloved horse for Marchese and his friends and family. What he wanted was a court order to go in and retrieve the horse's remains so that he could take it and cremate it. The state agency that runs the landfill, however, said, look, we understand this issue. We're not, trying to keep Mr. Marchese from grieving his horse, but we can't allow people in because landfills just aren't meant for this purpose. Once something is in, we're not going to go in and try to disturb the infrastructure. We don't want to release any toxic gases or other hazardous material out to where it might harm public safety. So these are the questions that Chancellor McCormick suddenly had to consider on Christmas Eve.
And so how did she weigh the equities?
Chancellor McCormick said that this case was presenting new questions for her that she had never had to consider in all of her experience in corporate law and as a judge at the Chancery Court. First of all, has this ever happened? And has anyone been able to go into a landfill to retrieve something that was wrongly placed there? And then how was she supposed to balance public safety with the rights of this person whose property was taken without their consent? And so she said this was just a really, really hard question, that there was no doubt that Mr. Marchese loved his horse and wanted to do right by her and really just had a simple request. He didn't want anything else out of the landfill. He just wanted his property. But she had to acknowledge that landfills are really delicate things. And, balancing the equities required her to compare the relative importance of the public safety and a landfill infrastructure with, the dignity of this horse that was wrongly interred there. Ultimately, she decided that the risks to public safety and public health were too high to allow him to go into the landfill. The state argued during one of the hearings before her that really no one had ever been allowed to go into a landfill and search for something except for a murder case about 30 years ago, a famous murder case involving a gubernatorial aide named Anne Marie Fahey. That was a very big deal in the mid-'90s at the time in the area. But that was really the last time that the state could say, hey, these are the circumstances under which we let someone go in and search in a landfill that's been kind of already processing debris and capped over.
And how did Marchese feel the judge treated him and handled the case?
So this wasn't, the first time that Brenton Marchese had ever appeared before a judge in Delaware. Like I said, he's had some troubles, some personal struggles in his past. But for these interactions with Chancellor McCormick, he met with her over Zoom, with his attorney and the attorney for the state. And she really let him talk at great length about his relationship with his horse and why he was so adamant about retrieving her remains. He said, look, I didn't get what I wanted out of this experience, but I know that I was heard. And she let me talk and she listened to me and responded to what I was saying, not what she wanted to hear. And he said that he felt like she treated him with compassion and that he could at least walk away from the experience knowing that she treated him compassionately, even if she couldn't give him what he thought he should have gotten out of this.
Is he going to get another horse?
I did ask him that, and he said, maybe I'll think about it a year from now. Horses are expensive. He's a construction worker. He's not a guy who has a ton of financial resources. He was living paycheck to paycheck for a lot of the time that he owned Breeze, because this is a very large horse. She was about 2,000 pounds when she died. So I think he'd have to resolve some things financially before he could commit to another lifetime with a horse.
So you talked to Delaware lawyers, and what did they think about the import of this case?
It's really interesting. This opinion came out right after New Year's, kind of in between two big rulings involving Elon Musk and Tesla. Everyone was waiting for that second opinion regarding a settlement in Tesla over board compensation. So people were refreshing the court website. They noticed when things post. And I think when this one posted and it had Chancellor McCormick's name on it, and they actually read it and saw how torn she was in making this decision against the horse's owner, they were really struck by how she took the time when she's under fire from the world's richest man and all of his fans who have been just swarming the court with online criticism, that she would take the time to listen to this one man about his horse that he can't get back out of a landfill. That really struck people as that shows how special this court is, that it's not only set up to weigh these kinds of questions as though they are the most important questions put before a corporate board or billionaire. She was able to turn around this opinion really quickly, and she kind of let everybody walk away feeling like they were heard, even if they couldn't get exactly what they wanted. No one felt like they were disadvantaged or that she was biased against them or anything like that.
This is a great story, Jennifer, about how the Delaware Chancery Court has these two very different sides to it. That's Bloomberg Law Senior Correspondent Jennifer Kay. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.